This is Barry Zalma on Insurance. I am an attorney who has retired from the active practice of law and now spend my time as an insurance claims consultant, an insurance claims expert witness, an author, and producer of these videos. Today I'd like to speak about the examination under oath, which is a duty owed by the insured to the insurer as a condition precedent to recovery of any benefits under the policy. Every fire insurance policy issued in the United States, just like the New York Standard Fire Insurance Policy, provides that in the event of a loss, the insurance company can require the insured to produce documents and testify at an examination under oath, abbreviated as an EUO. By statute in those states like New York and California that have a standard fire insurance policy, the policy also requires that all risk or direct risk of physical loss policies that do not exclude fire must provide the coverages, or better, the coverages stated in the standard fire policy, so all property insurance policies have requirements for the insured to submit to an EUO. In Ransom versus Selective Insurance Company, a 1988 decision from New Jersey, the court reviewed the examination under oath provision in a policy and concluded that the insured was required to submit to the EUO and produce requested documents in accordance with the written demand of counsel, because the circumstances surrounding the loss aroused a justifiable suspicion of arson, and because the requests are specific, relevant, material, and reasonable. Applying the principles articulated in Ransom, and finding a reasonable basis to suspect that his claim of a theft loss was fraudulent, the court determined that the insured's failure to produce the requested documents constituted a material breach of the conditions of his policy, recognizing that the insurer's rights may be materially diluted by the delay between the loss and the resolution of the issue. The court held an insured in these circumstances must promptly file a declaratory judgment action seeking a determination of its obligation to produce the records demanded by its insurer under an insurance policy when the insured objects to their production. The insured may not wait to assert his rights until the eve of the expiration of the statute of limitations for filing suit to compel coverage. Such delay works too great a hardship on the insurer, who must be able to promptly investigate the legitimacy of claims. Reversing a trial court ruling compelling appraisal or arbitration under an insurance policy, the 11th Circuit Court of Appeal in Jacobs versus Nationwide Mutual, a 2001 decision, applied Florida law in holding that the insured could not prove that he had fully complied with the EUO and document production requirements of the policy. Similarly, applying Florida law, the court in Galindo versus ARI Mutual Insurance Company in 2000 refused to allow appraisal to go forward until the insureds had submitted to an EUO, and stated that insureds must comply with the post-loss terms of their respective homeowners' policies, which enabled the insurance companies to investigate the insured's claims and to disagree with the loss amount before the appraisal term becomes effective. The failure to appear at EUO was held to be an absolute defense in Lentini Brothers versus New York Property Insurance, a 1980 decision out of New York. The Intermediate Appellate Court stated, compliance with the policy provision is a condition precedent to recovery. No compliance with the provisions as to written proof of loss or sworn examination occurred. Thus, recovery is barred. The court held that failure to appear for EUO is a breach of the cooperation clause, even if the insured offers to cure the breach by answering questions after denial of his claim. The purpose of examinations under oath, that was first described in 1884 in a case called Claflin v. Commonwealth Insurance Company, the U.S. Supreme Court made clear that every question that was relevant and pertinent in such an examination was material to the investigation of the insurer and must be answered. It also clarified that a question is material when a true answer to it was of the substance of the obligation of the assured. The position taken by the court in Claflin has been upheld by every court that has considered it to date. For example, in the Seventh Circuit in a case called Gips Brewing v. Central Manufacturers, the court stated, quote, "We think there is no escape from the conclusion that these witnesses purposely refused to answer questions which were material to the inquiry. We see no basis for refusal to answer upon the ground that they were controversial, or that the answers thereto might have been used for the purposes of impeachment. Such a limitation would seriously impair and perhaps destroy the defendant's rights under this provision of the policy. We would think that defendants had a right to examine as to any matter material to their liability as well as its extent." Close quote. The EUO and the requirement that insurers produce relevant documents in the event of a fire or any other loss to property are essential tools to insurers faced with a possible fraud or other issue affecting insurance coverage. Insureds and their counsel will often argue that they are not required to produce tax returns or other financial documents because to do so would violate the so-called taxpayer's privilege or the insured's right of privacy. They may refuse to testify about subjects they claim are irrelevant or protected by a privilege or right of privacy. In most states, however, refusal to testify or produce documents can result in a forfeiture of claims presented by the insured. If, however, as a result of a fire, the insured has lost the documentary evidence necessary to adequately prove the loss, then the insured can only prove the loss by oral testimony at examination under oath, and an examination under oath, therefore, is to benefit the insured in fulfilling the insured's obligation to prove their loss. After taking hundreds of EUOs in my 52 years as an insurance professional, I recognize that an insured will often, by his or her testimony at EUO, remove the suspicions of the insurer that a fraud is being attempted and will find his or her claim paid promptly. The EUO can also convince the insurer that a fraud is being attempted and cause it to disclaim coverage. The purpose of the EUO is to allow the insured a medium to prove the loss, something that is a condition precedent of the policy. Sworn testimony is as effective evidence as documents for an insured to prove his or her loss. Failure or refusal to prove the loss deprives the insured of the right to obtain the indemnity promised by the policy. In Rimshaw v. Trust Insurance Company, a 2001 case out of Massachusetts, The insured failed or refused to provide financial records, including her income tax returns, credit card information regarding the purchase of items reported stolen, photographs, and receipts. When she failed, the insurer had no option and denied her claim. The Massachusetts Appellate Court reasoned that we think the resolution of Rimshaw's appeal is controlled in all respects by Mello v. Hingham Mutual, a 1995 case from the Massachusetts Supreme Court. In that case, the court agreed with those authorities therein cited, which hold that the submission to an examination, if the request is reasonable, is strictly construed as a condition precedent to the insurer's liability. Close quote. Rimshaw's EUO and the undisputed evidence of her claim gave rise to the reasonable suspicion that she did not have the resources to purchase the alleged stolen items, that she had a motive to stage the loss, that the insurer had the right to assure itself of the validity of the claim, and that the requested documents were relevant to that question. The insured in Rimshaw attempted to defeat the insurer's argument by claiming the insurer was not prejudiced by her failure to produce documents. The court rejected the argument. It found that the failure to produce the reasonably requested pertinent information put the insurer in the untenable position of either paying the claim without question and without any means by which to investigate its validity, notwithstanding the circumstance and amount of the loss described in her unsworn statement and EUO testimony, or being sued for breach of contract and unfair acts and practices. The court concluded that without finding that a showing of prejudice was necessary, the prejudice to the insurer was too obvious to warrant discussion. It was enough to state that the insured's blanket refusal to provide the reasonably requested documents even stymied the insurer's ability to show actual prejudice. Failure to appear for EUO was a priori prejudicial to the rights of the insurer. Similarly, refusal to answer reasonable and necessary questions is itself prejudicial. By so doing, it limited the insured's ability to refuse to testify or answer reasonable and relevant questions. A breach of an EUO clause that held that breaches of the EUO clause do not require a showing of prejudice. Rather, an insurance company only needed to show a material breach to prevail, was held by the Indiana Supreme Court in Morris v. Econ Fire and Casualty, a 2006 decision. Taking a contrary position, the Sixth Circuit Court of Appeal, applying the law of Tennessee in Talley v. State Farm, a Sixth Circuit decision in 2000, found the insurer was required to show prejudice due to the insured's refusal to submit to an EUO. It reasoned that a showing of prejudice is required before an insurance provider is permitted to defeat liability in the context of a fire insurance claim. Talley breached a condition precedent in that Talley refused to submit to an EUO. Tennessee courts appear to follow the approach where insurance policy condition precedent has not been satisfied to require a showing of prejudice before voiding coverage. The Talley court found there is a presumption, however, that State Farm, the insurer, was prejudiced by the failure of Talley to cooperate by submitting to an EUO. However, a plaintiff can rebut that presumption of prejudice with competent evidence, and that's the court sent it back to the trial court to determine if the insured could produce evidence that rebutted the presumption of prejudice. On the other hand, courts have routinely found that an insurer demonstrates actual prejudice when the insured's failure to submit to an EUO resulted in a delay to the claims investigation, as cooperation clauses fulfill the reasonable purpose of enabling the insurer to obtain relevant information concerning the loss while the information is fresh. This video was adapted from my book, The Insurance Examination Under Oath, 2nd edition, and is available both as a Kindle book and a paperback from Amazon.com and through my website, zalma.com, by linking and clicking on the link to the Insurance Claims Library, where you can learn about this book and other books written by me. If you found this video to be useful to yourself, please refer your colleagues to it. It's free. And subscribe to my blog and to my YouTube channel. Thank you for your cooperation and attention.